to stand upon the mountain and to magnify his name, to tell all the people and every nation that he reigns. Oh, Zion is calling me to a higher place of praise. How many of you have ever heard that song? I know there were more hands than called for me doing a solo. So I'm not hardly trying to entertain you folks here. Amen. So I'll bring the mic out and stick it in front of you and make you do a solo if I don't see you singing. So let's sing this through one time and let's get into this. Zion is calling me to a higher place of praise, to stand upon the mountain, to stand upon the mount, and to magnify his name, and to magnify his name. Tell all the people, to tell all the people, every nation and every nation that he reigns. Oh, Zion is calling me to a higher place of praise. Let's bow our heads. Eternal, everlasting God, we thank you for this unique and particular day that we have never ever seen before. And once it is past, we shall never ever lay claim to it again. This is the day that the Lord hath made, and we shall rejoice and be glad in it. We thank you for those who have gathered here today to sit down and attend themselves to the meticulous but oh so important matters of preparing to exit this world and leave a legacy behind. We pray, dear Lord, that our minds would be engaged, our hearts would be engaged, so that, God, we can do all things decently and in order. We thank you, God, for our presenters, and we pray that they be effective and clear and impactful and helpful and edifying as they walk us through the pathway to preparation. We thank you for those who are on their way. We pray, dear Lord, whether they're driving by law or by grace, that they will get here safely. And we thank you for those who will access these materials via the YouTube later. All things come of thee, O Lord, of thine own, as you freely give. In your name we pray, and God, we give you thanks. Let us all say amen. Before you take your seat, give God a praise offering with the clapping of your hands. And give the person to your right and your left an affirmation for being here relatively close to time. Relatively close to time. If you're coming in the door now, you are late. We want to let you go on time on the end. That means you have to be here on time on the beginning. 10 o'clock is not the time for you to pull up in the driveway, because then you're late. 10 o'clock is not the time for you to be signing in, because then you're late. 10 o'clock is not the time for you to be sitting down and stepping over people, because then you're late. 10 o'clock is the time for our first presenter to stand. Amen? Sit. So you all come on in, come on in, come on in, come on in. We just want you guys to move up the time so that we can get every bit of this time, because they have a lot to cover in a short period of time. Let me re-present our presenters so that we know who we have in front of us once and again. All right. First, we have Mr. Ray Csnnell, who was born in Kingston, Jamaica, and grew up in Morant Bay, St. Thomas. He's a man from the islands. Ray came to the U.S. in August 1972. He was married to Dr. Anita Csnnell, and they have two children, Raymond Kay, who is a real estate developer in Oakland, and their daughter, Bianca, is a King County prosecutor. They also have two beautiful granddaughters, Ray graduated from the University of Washington School of Business and went on to graduate from Seattle University School of Law. He has been a practicing attorney in Seattle since September 1986. He is a solo practitioner in the Seward Park area. Ray's area of interest are wills and probate, real estate transaction and litigation, and 3, representation of injured parties. He has presented to various audiences on these subject matters on several occasions. Ray is a Rotarian and has traveled to Ethiopia to administer polio vaccinations. So he not only is a lawyer, he's a bootleg doctor. Don't let Ray run up on you with a needle. Additionally, he has traveled to Uganda and assisted in building houses for displaced workers and building and repairing of boreholes, wells, another word for wells, for villagers. Ray is currently working on a project to provide water to over 3,500 people in Trenchtown, Kingston, Jamaica. So he is a jack of all trades, if you may, an attorney of conscience. We also have, who will be co-presenting with him today, born and raised in, Keith Armstrong is born and raised in Oklahoma City. He says, the heart of America. I'm not going to co-sign that, but I call them basketball team thieves. Next time you go home, tell the Sonics we said hi. He's academically trained at Oklahoma State University, receiving his Bachelor of Science in Business Administration. Mr. Armstrong obtained his law degree at Washburn University School of Law in Kansas, as he says, the land of Oz. There he studied international business law. International influences landed him in London, England, for the summer, studying administrative law and the start of the European Union. Since then, Mr. Armstrong has become a pseudo-ambassador at large, hosting several conferences in Kansas with foreign ambassadors from the USSR, France, Japan, Denmark, Hungary, and Sweden. So we have a bootleg doctor and a pseudo-ambassador today. Mr. Armstrong moved to Seattle in 1994, where he was a Washington State human rights, civil rights investigator. Then in 1995, he did trials for the Attorney General's office representing the Department of Licensing, Health and Employment, Security Department in over 1,000 cases in Superior Court, Court of Appeals, and Supreme Court. Mr. Armstrong has extensive experience in business, estate planning, real estate development, employment law, and construction. Along with feeding the homeless at his local church, Mr. Armstrong and spouse Andrea Armstrong manage a veteran services program to assist and house homeless veterans. Mr. Armstrong has studied international and administrative law in London, England, France, Italy, and Japan. In 1996, he taught a seminar in Japanese on criminal procedure and legal analysis of the O.J. trial to Tokyo law students in Japan. Did you tell them O.J. did it? O.J. did it. Don't you say O.J. did it. No. You speak Japanese? He and my son Sam are the only 2 black men I know who speak Japanese. Amen. Mr. Armstrong's experience is switch from public law practices to private law practices every 5 years, assisting government in consulting roles and private company exports to foreign lands. Today he lives in Tacoma, center of the known world, with his spouse, another government attorney. Mr. Armstrong is very active in the community, encouraging legal forums, business development, workshops, apprenticeships, workforce development, and entrepreneurial pursuits for beginners in business. Mr. Armstrong enjoys fashion, travel, fast cars, slow down, bro, Asian and African cultures. His law firm, Strong International Law Group, LLC, focuses on business law, estate planning, and probate and veterans disability appeals. He is blessed to be here to help you focus on leaving a legacy of wealth for your family. The Kennedys shouldn't be the only ones with generational wealth. That's a direct quote from him. The Kennedys shouldn't be the only one with some generation no wealth. Somebody say, I'm going to get me some money, and I'm going to leave some money. Amen. Won't you give God a hand praise for our two very capable presenters? Oh, come on, do better than that. Without further ado, I'm going to turn you to the hands. And I want to ask this of you all before Ray comes. I want to ask you all to covenant with God. I say with God because you'll break that promise with me or anyone else. I want you to promise God you will be here each week. The first thing we learned two things last week. Number one, we learned that not even dying is free. Not even dying is free. So if you don't have burial insurance, if you drop dead right now, you're assuming someone else's money to put you into the ground. Right? So not even dying is free. And then secondly, we learned that none of us in here are totally prepared. So we want everybody to walk away with a checklist. Because this foolishness of, oh, my kids know they're going to get it. That's not how the law works. It's not how the law works. Oh, I don't have no kids. I don't have nobody to leave it to. That you got money in the bank. Who gets it and how? Oh, I'm going to leave the house to all the kids. They're going to split it up. Are they going to sell it? Are they going to live into it? That's a fight set up. So all the folkways and myths we've got, oh, I don't want them to know where my will is at because then they'll go take it. That's not the way the law works. So Jesus said, ye shall know the truth, and the truth shall set you free. Let us receive our presenters.
Thank you, Reverend. Good morning again, ladies and gentlemen. I'm Raymond Connell. And just clarify in my introduction, it was to rebuild houses for displaced widows in Uganda. Thank you again for coming out this morning. It's been a real joy and thrill for me to see this many people. I appreciate your questions and brief housekeeping item. I will go on for about a half an hour, and I'll dedicate the rest of the time to my esteemed brother, Keith Armstrong. Keith will present to you primarily in the area of trust. That's a big item, so I want to leave as much time for Keith as possible. What I'm going to do for you this morning is recap what we talked about last week, spend about 2-3 minutes on that, and then I'm going to talk about power of attorney, live-in will, physician's directives, talk about probate. You have a lot of questions about that. And I'm going to attempt to take the sting or the bite out of this area called probate. And my hope is that when we walk out of here today, we'll feel more comfortable, more knowledgeable, and we'll know the types of questions to ask when we meet with our professionals to see about taking care of these items. So without further ado, last week we talked about legacy, and we defined what a legacy was. Okay, legacy simply is leaving an amount of money or property to someone or an organization, and you do that in a will. It's normally known as an endowment or inheritance or bequest. What is a will? It's a legal document expressing the wishes of the testator. The testator is the person who drafts, who signs the will. And it takes effect upon death. It names a qualified executor, and you may recall what the executor, the personal representative or executrix is. And the qualification primarily is that they must be over 18 and must not have a felony conviction or a misdemeanor with a conviction of a moral turpitude crime, which involves stealing. Next. We talked about a simple will and what's involved in a simple will. And we can, for those of you taking pictures, we have the outline provided online, and my capable IT person will have that available. We talked about a simple will and what it involves, and the main thing to remember about that is it will provide for the disposition of your assets and pay particular attention to the fact that if you have minor children, you can make accommodations for them through the will, because if you don't have a will, the court will make that determination. But you have the ability to make that determination while you're alive, and you put it in your will. The will is simply your opportunity to be creative in what you want to say and what you want your will to express. You may recall I coined the phrase, your will is a voice from the grave. Next. Using your will to create a legacy, and was a little bit ahead of myself. It expresses the testator's desire. The will can carve out specific provisions for individuals. So if you want baby to have the house or the or the diamond ring, the earrings, all those kinds of things, you put that in your will and specifically name it. I said that for same-sex partners, a will is especially important. If you get a will drafted in Washington State and you move to some remote state, I won't say anything, but let's say you move further south, in a southern state where same-sex partnership is not recognized, the will from Washington State will be recognized there. If you go there without a will, then you can run into serious trouble. I've seen it in my practice years ago where people, same-sex partners, were together for many, many years. You couldn't tell me that these people weren't in love or didn't love each other. And somebody gets sick and they go into the hospital and they can't see the person because they're not blood relative. It can be very devastating, and my heart goes out. It's very tough. Or guy says, I want so-and-so Tom to take care of me. I leave everything to him. He doesn't have a will. The father and the mother comes in. They haven't spoken to the kid from the day he said, declare that he was gay. They threw him out of the house, but suddenly he gets sick and he has some money. They all come back and they want to live happily ever after. So the will takes care of that. The will is not a perfect tool. Let me be very clear about that. But don't let the perfect be the enemy of the good. It will take care of most of the problems. And especially with folks moving out of the state of Washington into some other place where this can become an issue. If you want to leave a legacy, you want to leave money for your church, leave money for a university, for higher education, this is an opportunity to express in the will what it is that you want. Next, we talked about creating a legacy by writing in specifically what you want to do. $10,000 to United Negro College Fund or my church. If you want to, we talked about using life insurance as an item of doing that. We talked about contacting your insurance broker and saying, yes, so let's say, for example, you have a policy of $100,000. You call your broker, Mr. Broker, I know I have a $100,000 policy with Metropolitan Life. I would like to leave $10,000 to my church. I want to leave $10,000 to United Negro College Fund, the University of Washington. These are just examples that I'm giving you, of course. And tell the broker that's what you want to do. Then Mr. Broker or Mrs. Broker sends you a change of beneficiary designation form. you sign that, you tell them specifically who gets what, and at the time of your death, the insurance company writes a check to those facilities, and it doesn't come into your estate. Clean cut, straight there. You can grant a life estate to individuals, but I don't want to get into that. That's more Keith's area, what a life estate is. And it could be used for a tax planning tool along with a trust. So they're not mutually exclusive. Next. We talked about after you created your will, what do you do? A lot of problems that I have in my practice is people do a will, you hear that this person's supposed to get the house, and that one will get the money, and we can't find a will. Well, too bad. If you can't find a will, that's it. So, I recommend that you either put it in a safe deposit box, you keep it at home in a safe place, or what I find to be very, very efficient, and I would strongly recommend, is using the court repository at King County or the county in which you reside. I'm biased towards King County because that's where I practice. And this is where I've experienced the court repository primarily. But in Pierce County, Thurston County, Snohomish, all these other places, they have their own form which specify their county. It's a $20 fee, and it's extremely efficient. Next. I passed out handouts called Probate Data Handout, and if you don't have a copy, we still have some, and our capable IT person will put it online, and you can access it. And the primary purpose of that is to get an idea of the things that you need to have when you meet with your professional. And we're coming into phase 2 of my presentation. Power of attorney. A lot of you have questions about power of attorney. And what is a power of attorney? It is a signed and drafted document by the principal. The principal is the person who is given the authority over somebody else who's an agent to act on your behalf. And you're mostly familiar with it, with what a power of attorney is. But I want to point out a couple of things that might not be so obvious to you. Is I'm sure everybody here has a story about their parent or grandparent who went into a nursing home and the abuses that occurred. Sometimes your grandfather may end up marrying his nurse, his care provider, or suddenly, I'm talking about stuff that I see in my practice. This is not crackheads that I'm talking about now. But these are non-crackhead people that's doing this stuff. So in 2017, the Washington State Legislature changed the Power of Attorney Act to provide that a power of attorney must be notarized or witnessed. And they made it very clear that a person at the nursing home or a care provider cannot be a witness, and they cannot notarize the power of attorney. And that's obvious from the kind of abuses that went on in the past. The power of attorney grants the agent, the person who's acting on your behalf, complete authority over you. There are 3 types of power of attorneys. The power of attorney can take effect. 3 types of power of attorney. There's a specific power of attorney, a general power of attorney, and a durable power of attorney. The specific power of attorney is obvious. It does a specific act. For example, I was buying a house with my son, and I was leaving for Africa. I gave him authority to sign for me just for that one transaction. He does not have the authority to go into my bank account or sell any other property. That's it. sign for that. When the act is complete, the power of attorney terminates. A general power of attorney is one where you want to give somebody broader powers to act on your behalf, and they can do pretty much anything, no limitation, except they can't do estate planning for you. The durable power of attorney that most people in here are familiar with is the one that provides medical provision. Means that if the person, and you have to be really careful in trusting the person that you're granting this kind of authority to, because it's pretty broad. And they can make medical decisions, and it also, there may be some provisions in it that if you become incapacitated, then if there's a need for a guardian, that person would be appointed as your guardian. So the durable power of attorney is a pretty powerful instrument and should not be taken lightly. You have to make sure you trust this person. Next, when does a power of attorney terminate? Well, it terminates upon death. The principal becomes incapacitated if the power of attorney does not provide for durable power of attorney. So we're talking about a general or a specific power of attorney. But the durable power of attorney continues, but it ceases upon death. The principal revokes it, so if you decide, hey, I just found out that baby is on crack and I don't like that too good, you want to take him off, you can do that. I'm only using the crackhead because they're easy prey that we all can focus on, but we all have a crackhead here and there in the family. A power of attorney provides for termination, yep. And it tells you when it will be, how it will be terminated. After the purpose is accomplished. I told you about giving my son authority. So once he signs off on that deal, the power of attorney ceases. The principal revokes the agent authority, or the agent dies, obviously. And so if you didn't have a provision for an alternate agent, then it ceases. Durable power of attorney stays in effect if the principal becomes incapacitated or unable to handle matters on her own behalf. Live-in will physicians directive, they're two same term. Live-in will and other advanced directives are written legal instruments provide regarding your preference for medical care. So in a nutshell, if you are terminally ill, sick, and there's no hope, you're in a coma, it kicks in, tells the doctor, the hospital, your care provider, that once the medical evidence provides that it's terminal and it's useless, and you don't want to remain alive or stay alive on artificial fluids and machine, then it's your right not to receive that. But if you don't have this in place, the medical people cannot make that decision. It's not something that one can make capriciously. It's all based on the medical evidence. So if the doctor determines that this is it, then people, they can start turning off the machine. A live-in will make your wishes, you make it known, and you want to provide a copy to your healthcare providers in the hospital. Important to know, a live-in will does not distribute your wealth or your assets. So let's take, for example, you have a live-in will. Generally, a will would distribute your assets. A live-in will doesn't do that. All it does is say that if you're terminal and there is no hope, not in so many words, I say it a lot fancier than that, then you, if you die, the living will does not give any authority to distribute your assets. It's the will that we talked about that will do that. You keep your living will on file with the medical providers, your doctor, and the hospital. And a lot of times when you go into the hospital, they'll ask you if you have a living will. Don't be shocked. It's a practical question. I just had a doctor ask me that last week. At a physical, the guy asked me, "You have a living will?" So what are you talking about? You know something I don't know? So, I didn't get that memo. So, don't feel shy about it. Just go along with the program. But I would strongly recommend that when you do your will, and this might be a cost-effective thing to do, and follow me in this. You do your will. You could get your power of attorney done at the same time and your physician's directive, and here's why. Let's say you come in to see me and I do a will for you. It takes me 2 hours to draft the will. A couple months later, you come back and you ask me to do a physician's directive. It takes me maybe 45 minutes to 1 hour to do. You got to meet you, go over the will with you, get all the information. And then we sign it, got to bring in witnesses. You say, I thought about it, and I think I want to do a durable power of attorney. So you come back in again, it's another 45 minutes. If we do it all at the same time, I have the same information right there, right? Can do it now. I have my witnesses, and we can get it all taken care of right there at the same time. So it might be, from a cost standpoint, if you know what you want to do, and with your knowledge that you have now, to consider doing them all at the same time. Probate. What is probate? And that's why y'all are here, because this big, fancy legal term, probate. Probate ain't nothing but a legal process in which the will is accepted into the court. And I'm assuming it's the same principle if you have a will or if you don't have a will. So I'm assuming we all have a will. But it works the same without a will. So the probate is where the tire meets the road. And this is primarily legal stuff, okay? This is where the lawyers earn their keep. And it's a fact. Probate costs money, okay? But it's more expensive if you don't have a will, and I'll get to that. It's a legal principle, and let's assume that this is the will. You call me, and I draft some documents, and you sign it, and I take it to court. You don't even have to go to court with a lawyer. And I take my documents in with a copy of the death certificate, just a copy. The death certificate isn't filed, just to show the court that, yeah, the person really died, and here's a certificate from the county. And the judge signs the order admitting the will to probate, and we appoint the personal representative. Of course, the personal representative or the executor or executrix is in the will. And then they grant the order to admit the will to probate, and we get a letter of testamentary. And pull up the letter of testamentary. You should have a copy in the handouts. And this is basically what the letter of testamentary looks like. This is a fictitious one. You all don't know Jane Doe. Somebody knows her? Okay. Anyway, this is one that I made up, and this is kind of, the handout is more precise as to what it looks like. So when I go to court, this is what the judge, the clerk gives me, is a letter of testamentary. That letter you take with you to the bank, to the credit union, to the employer, to get the Boeing VIP or your life insurance. You send us in with a certified copy of the death certificate showing that Jane Doe or Jack Doe was appointed as the executor of the estate, and Jack has full authority to get all the information. But this is a letter that you use to tell everybody in the world that you have authority to act on Mrs. Doe's behalf. So we go to court to get this letter, and this is what gives you the complete authority, uninhibited authority, to act on Jane Doe's estate. Next. Probate includes proving the validity of the will. And let me say this. I know in Washington State, the court will bend over backwards to find the validity of a will. I mean, unless it's really outrageous, the court will not accept the will. But generally, the court would rather find validity of a will than invalidity. And there's what's called a rebuttable presumption that there's a will. So you can test a will. You can bring in outside proof that this Ms. Doe really signed this will, and this is what she intended. So the court would like to find that there's a will, because if it's not, and if it's approximately equal to a will, they will pretty much go along with it. Unless it's really egregious, where the person was forced at gunpoint to sign the will, and you have proof of that, then the court will not go along with it. Identifying beneficiaries entitled to the distribution, so the will specify who gets what. Gathering of the assets, this is part of what's done during probate. So the lawyer will write the insurance companies or the employer, whoever has the assets, the brokerage firm, for complete detail of that person's assets or investment. And we're entitled to it. The only thing we have to provide is a certified copy of the death certificate and the letter of testamentary, certified copy of the letter of testamentary, and then boom, it's done. Identifying potential creditors. We file notice to creditors, and that's posted in the newspaper. It runs for 6 weeks, and the reason why probate will take long, somebody will ask me later on, and I'm sure, and I'll answer it now. The earliest that probate can close is between 4 to 6 months, and here's why. You publish it in the newspaper under the notice of creditors, and I usually use the Daily Journal of Commerce is where I publish my notice to creditors. Most businesses use that. And it runs for 6 weeks, 6 consecutive weeks in a newspaper. And they have 4 months after the first date of publication to file their claim. If they don't, then they're out of luck. However, if you know of a debt, you have a hospital bill, you have a credit card bill on your dining room table that was sent, and you don't pay it, but this poor banker or credit card company didn't see it, you're not exempt. So if you are aware of these debts, you have to send them a copy of the notice of creditors, and if they don't file their claim within 4 months after you send that letter, then they're out of luck. So, had a client, his wife passed, she had a college loan debt, and the lenders kept calling, and the guy said, look, my wife is dead, this was a thing that you did, it's a separate estate. No, you got to pay it. So we filed probate, and they weren't aware of the notice that was put in the newspaper. So I sent them the letter, the notice to creditors, and I also notified them that they have 4 months from the date of receipt to file a claim. They ignored it. The 5th month, they started calling again. So, well, didn't you get my letter? No, so I pulled it out, showed them that they missed the deadline, and they were out of luck. So the estate didn't have to repay the $15,000. So you got to know, and you take advantage of these situations. Identifying potential creditors, so that's what we're talking about. Resolving challenges to invalidity of the will. And this is the last time I'm going to mention a crackhead, but this is from experience, folks. I'm talking the truth. The crackhead will have a line of credit on crack. And the crack dealer would call to find out, well, you know, I just want to know approximately when we can expect the distribution of so-and-so's inheritance. So what are you talking about? Well, you know, no, I don't know. So, well, you know, Ms. Doe didn't leave anything for your crackhead boy. So the dealer talks to him and says, hey, man, you are an heir to your mother's estate. Why don't you challenge the will? So the crackhead files a challenge. We have to defend that. So you put in the will a provision that anybody who challenges the will gets either $1 or nothing. So the crackhead and his dealer are going to be out of luck, because the courts are aware, especially if the dude shows up in court. Judge takes one look at this guy and says, oh, man, he's a crackhead. And they're not going to invalidate the will because of that. You have to pay taxes. We talked a little bit about the estate being over $7.2 million. In Washington State, you have to pay inheritance tax. I believe the amount for federal taxes is about $25.5 million. Then you have to pay federal inheritance tax. But most of you in here should worry about the Washington inheritance tax, because it's really easy to get above 7.2 if you own a couple of houses, your 401k. So, you know, then you want to talk to Keith about some type of planning to get that out of your estate. And then in probate, we distribute the remainder. We call it residue. Write that down. It's a real fancy word. The residue of the estate is what's passed on to the descendants. Next. When is probate necessary? Hey, hear it from a lawyer. Not every estate needs to go to probate. I passed out some forms showing the small estate. It's called an affidavit of small estate. So anything, some of you from the old school, when the amount was $30,000 and it went up to 60, and it's now $100,000. So if you have an estate that's under $100,000, there's no real estate in it. And I think also if you have a minor child, it wouldn't be eligible for that. But generally, if you have an estate of under $100,000, you could file this affidavit of small estate. And basically what it does, it gives you, with this form. It looks kind of like a letter of testamentary. It would give you the right to maybe get the last paycheck for your child who was killed, or may have been terminally ill, and so you can get the last paycheck or whatever small funds that they have. But if you have real estate in the estate, it won't be eligible for the small estate filing. Probate is necessary in the unfortunate instance of a wrongful death. The cop kills your son or your daughter over some weird stuff. You see it all the time in the newspaper. In order for you to pursue a wrongful death claim, and usually the person doesn't have a will, but in a wrongful death claim against the police or a car accident on the freeway, somebody dies, somebody is responsible for your death, you'd appoint an administrator, and the administrator is the one who would pursue the death claim. That's the only way you can start a wrongful death claim. So whenever you see these lawsuits, settlement, cops killed somebody, and I'm using that as an example because that's most relevant, an executor, administrator, administratrix, or executrix is appointed to pursue the wrongful death claim. And that's really important. So you file probate if there's real estate in the estate. That's very important because the personal representative, administrator or administratrix or executrix is the only one who can sign the deed to transfer the property. So Ms. Jane Doe dies, Jack Doe is appointed as the executor. He can sell the property, and he's the one that signs the deed as if it were Miss Jane Doe. Next. Is that it? Okay. Wow, that was good. So, in conclusion, probate is necessary if the estate is over 100,000. The person has a will, and the assets the estate has real estate, and there's a will, then you'd want to do probate. Thank you. Reverend, I turn it back over to you, and give your attention to my esteemed colleague, Keith Armstrong.
Thank you, Ray. Glad to be here. Greetings from Pierce County and Tacoma, the city of destiny. Yeah. I want to just definitely give you guys kudos for this educational series. This is really, really important. And for those who are not millionaires, it's best to have a plan of your estate. Otherwise, you will have no money, your family will have no money, and there'll be no legacy. So I love the idea of having a legacy, leaving a legacy. The topic I'm going to focus on is how to avoid probate. And there's several ways to do it. Some of them you already know, and some of them you don't, and we're going to go over those just a little bit. The first thing I want to talk about is estate planning is, as the definition up there, is a process of managing your assets and your wealth. And most of us have an estate. Whether you're single or married, you have an estate. The best thing about it is to get some real estate into your estate, because a lot of the wealthy people in this country have started with real estate. It's a good way, a good basis. So if you're out there and you don't have a house you're renting, that's good. If you're not saving money over here on the right, get you a house here on the left. Either way, you're going to have an estate. But it's better to have a house because you can maneuver with the house. You can pass on. This is how the Kennedys started. They are rich. Everybody's got a trust fund, millions of dollars. But they started with real estate. And they used that, and they put it in a trust, and it rolled over, and it rolled over. And that's what you can do. You can start a legacy with $25. You can save $25 for the baby kid that you really have not paid much attention to, but for $25 you can start an estate, and eventually they can have real estate. So that's a lot of things you want to think about is get started, because estate planning deals with control. That's what you're trying to do, control your assets for you, not for the state of Washington, not for nonprofits, but for you. And that way you can actually have an estate and a legacy to pass on. If you don't plan, it's going to be complete chaos. As Brother Ray and I can tell you, if you don't have a will, there are going to be fights. And I'll tell you who are the worst fights. It's the Christians. They fight more. They fight way more than the atheists. I'm telling you, because you got your heart and your mind, and God told me this, and the will said that. So I'm telling you, please get a will. If you believe in yourself and God, please get a will. It's going to help you. Next one. Your estate is going to be distributed two ways. If you have a will, it's going to go to what the will says. If you don't have a will, it's going to go to what that judge said, who you don't know, who's probably 70, knows none of your culture or your kids or your family, and don't care about you. That's who's going to decide your whole estate if you don't make a will. So you make one, don't let them make one. And now what I'm going to talk about is some ways for you to help manage your estate. If you don't have a will, let me tell you how easy this is to get a will. I would rather you have an attorney, to make it specific. I would rather you do a will according to you. But it's so simple. Get you a napkin while you're at dinner and say, I want this, this, and this. Get two witnesses, sign it, that can go to court. It's that simple. That's not good, but it's that simple. And then you come and see Ray and get a real one. But get something, because what makes it valid is the two witnesses. And you said, I'm in my right mind. I want the house to go to Bebe. I want the boat go here. You got to do it. If you don't, your whole life will be in the charge of somebody else, and it's not pretty, I'm telling you. Now, if you don't make a will, I'm telling you, you're just talking. Everything you do does not matter. Everything you say does not matter. You have to write it down or it don't count. You got to have witnesses to do that. And make sure, as Brother Wade said, make sure the witness is over 18 in their right mind. You know what you're doing, they know what you're doing, and they watch you do it. That's it. Even if it's on the napkin, you can do that. So definitely a will is good, but you got to do some things to make it legal. What I want to talk about is how to transfer your estate. One of the ways, there's two categories in transferring your estate. There are some non-probate ways, and there's some probate ways. Anybody ever heard of a joint tenant account? Joint tenant with right of survivorship. In Oklahoma, we call that a poor man's will. That's what they do in Oklahoma. They actually put a joint tenants because, my daughter's on my account, and if I die, it goes straight to her. That's a way to pass on without even going through your estate. And you don't need a will to do that. If you can do that, that's a good way to do it. At least somebody's on the account with you. Because if you die, the bank is not going to talk to your family. They won't talk to your pastor. They won't talk to your lawyer. They won't talk to anybody. Matter of fact, and I tell my clients, do not tell them they died until you do these things. Because if you say, I'm here for my daughter and she died, I said in the middle of the sentence when you say the word die, they stop talking and you are now locked out forever. That money will sit there and nobody will be able to get it. You have to have legal capacity, and that's why the will comes in. But what these insurance and banks are really good at is stopping you from getting your money. Really good at that. So you have to be very careful and follow your attorney advice on how to manage your estate. And when you go to the banks, when you go to the insurance companies, you have to say magic words. I have a will. I have a power of attorney. I have all of these things, and I want to transfer my estate. The transfer of your estate outside your wills or some other ways. A joint tenants with right of survivorship, that's one way through a bank. If you have insurance, that passes outside your estate. So when you say, I have 3 kids and I want my $100,000 life insurance to go to those 3, it goes to those 3. Doesn't come to your estate, you don't pay taxes, doesn't go anywhere, it goes straight to the people. So I want everybody to go back to their insurance and their 401k and update those beneficiaries. Because some of us have baby's kids as our beneficiaries when they were young and cute. Now that they're on crack, that's where that money is going. Update them once a year. If you remember, pay your taxes, update your beneficiaries, because it's going to go to those people you wrote. Some of us actually have ex-spouses. You know, when we was in love at 18, life insurance going to them. You haven't updated, and you've been keeping that spouse out your mind for 40 years. It's going to that spouse. They don't know that you've been married again and you have another family, and they don't care. Whoever's on that beneficiary is where it's going, and it goes outside your estate, so you don't have control over it. Update it this week. Update it and set up. There's one other thing that's very important. The best. I'll tell you that. I'm going to give you a nugget. This is the best news I have heard in 20 years. Right now, you have to probate your estate if you got real estate. You got land, real estate, that's it. There's nothing you can do. But you can take the real estate out of your estate and put it in a trust. But there's another way. There's a brand new law, to me it's new. 2014, the state of Washington passed a transfer on death deed, which is where, Brother Braxton here has a house. He does a transfer on death deed, goes to his oldest son, and it's still in his estate. It's still in his estate. But when he dies, it transfers to that son without going through probate. It's the only way to get transfer of real estate out of your estate without taking it out before. I mean, it's really unusual. Most states. Oh, I'm just an example. Just an example. Oh, I heard him. He only has one son. We're not talking about the other child. For example, Pastor Braxton's one son. He did not put it in a trust. He did not do a joint tenants. He didn't do a right of survivorship, but he did do a transfer on death. And it has an advantage of it keeps the house in your possession and in your estate. But when you die, it goes out. And you present a death certificate, pay like $10 excise tax, and that's another way to transfer your house too. So it's not good for everybody, but it's an alternative to doing a trust, and cheaper. So there's some things you can do. And the next one, transfer your estate. Your beneficiaries, you want to make sure you update all your beneficiaries because that's where they're going to go. And most important is having a contingent beneficiary. Not just the first one, but what if they die? Where do they go? If you don't do that, it will go into your probate. So the thing you're trying to avoid, it'll go right back to where you go. So you want to have a primary beneficiary, even if it's all your kids. Who's secondary? Church can be a contingent beneficiary. Your aunts and uncles, nephews, nieces, a nonprofit. Anybody can be a contingent beneficiary, but you want to make sure that you have a primary and a contingent so that you do that. So next. To avoid the probate, like I said, it's a couple things. Joint tenant accounts is one way. Community property already takes half of your estate anyways. For you married folks, half of the house is yours. Half of the house is hers. She's going to get half no matter what you do. You get to will or distribute your half. So community property takes half into there. And so that already is happening. But you get to determine that other half, what happens. And then, of course, a living trust is another way for you to distribute your estate and avoid probate. I talked about the transfer on death. They have these pay on death accounts at the banks where if you die, it pays somebody. Life insurance does the same thing. It pays on death. And the transfer on deed is something new. It transfers the deed on death. And it's not a financial account. It only deals with transfer on deeds. A lot of people say, well, I have a will. Why do I need a trust? You need both. If you want a trust, you probably need a will too, because there will be things that you don't remember, things that you forgot. And when you do this, say you did this in 1996, well, it's 2020, you probably have gotten some things that you've accumulated. And if you didn't put it in the will, it won't count. So having a trust is good, but you need a will as a backup. So you always need to do something like that, even if you don't have real estate. Some of you are married and kids. Very good idea to think about doing a trust or to get a lot of things out of your estate so don't go through probate. But if you're single, it may be more important for you. Where does your stuff go? You're a widow. Where does your stuff go? You can actually do some of these probate avoiding things or a trust. Get it out of your estate, because if it's in there, it's going to be subject to the state coming in and creditors. Everybody's going to attack your estate trying to get some of that money. Get it out of there so that you don't have it. So when they look for it, it's going to be there. Now, here's some red flags for you to consider. If you have these things, you want to consider a trust or something to avoid probate. If you got children from a previous marriage, you want to talk to a lawyer. If you have a spouse that you don't get along with, I don't know if anybody's out there like that, you might want to get some legal help in getting a trust. If you're in a relationship that your parents or your family don't approve of, you might want to do some planning, because they're going to fight everything you do. And if you don't write it down, everything they say is going to go. Nothing you say is going to go. If you don't write it down, it don't count. If you have a history of mental illness, anybody in your family have mental illness, that's a good time for you to get some things out of your estate with some estate planning. If you don't do it, somebody else will. And it'll be their interest. It'll be the creditors. It'll be the state. It'll be the hospitals. It'll be all those people who will be looking for your money. So I put in there, and you're going to have a copy of the PowerPoint, the difference between a simple will and a revocable trust. The wills are when you die. The trust is during your lifetime. So when you do a living trust, it's while you're living. And it operates after you die. With the will, it's only after you die. The will goes through probate. Trust does not. The will is a public document. As Brother said already, you can put it into the public. But eventually, when you go through probate, a will is going to be public. With a trust, it's a private document. You may never have to go outside your house. Nobody may ever find out what's in your trust because it's private. The public will puts all your stuff on public. Trust, it's private. The will does exactly what it says it's going to do, and the trust actually does the same thing, but it's flexible because you have a trustee to make decisions that are discretionary. You may have 3 kids and only one's left. Well, that trustee can actually make a maneuver with the trust. With the will, it's got to do exactly what it says. Anybody have any land down south? I know a lot of us have a house here, but we have property or thing down south. You may be a good candidate for a trust, because with a will, you're going to go through probate because it's land and real estate. Well, you got to do another probate in the other state, and you got to hire another lawyer to do the same thing. It's crazy and horrible, and I've had one lasted 6 years, and we still didn't get it all right. But it was crazy. This is a good way for you to put it in a trust, because it allows you, every state will allow the trust to put all of your real estate in one place and keep it out of your probate. And of course, there's some tax benefits too. So just the comparison is, don't do one or the other. You probably need both. Brother Braxton here, our great pastor, he is saying that we need some vocabulary. So I want to give you just 3 or 4 here. Of a trust. A grantor is the person who gives the property. A beneficiary is the one who receives the property. The trustee is kind of like the manager of the whole thing. So think of it as a manager. You don't own it. It's not yours. You're the manager. And, of course, the corpus is all the assets that you put in the trust. And we're going to talk about the cookie jar in a minute. Probate, as Brother just gave us, it's the process of, and I look at probate really simple. You gather up all the assets, you gather up all the bills, you pay the bills, and what's left goes to the heirs. So your whole idea of an executor of the estate is long and trying, but that's all you're doing. You're gathering assets and bills, and you're paying and giving the rest. That's really what you're doing. And non-probate estates, that's like insurance, joint tenant with right survivorship accounts, some IRAs that you've got beneficiaries. Those things are non-probate. They go automatically, so you don't have to do anything. Why would you establish a trust? Now, some people say, I want to do a will because I know that. I don't know about a trust. I don't have that much money. I don't have a house. Why would you do a trust? One, it avoids probate. Two, it controls your assets, even while you're living. Three, it protects assets from creditors. Some trusts actually protect all of your assets. Some give you limited protection. So it makes a difference on which one you have. It also provides privacy for your heirs. You may have some things you want your family to have, but you want everybody else to know you have it. Put it in a trust. It'll go to them, and it goes in a private manner. It doesn't go to the public. It also avoids a battle over the will. People will try to contest the will if they think they can get some money out of it. A trust is a little harder to you can contest it too, but it's a little harder to do. And plus you got a trustee there. With the will, the person's gone. If you have somebody who has special needs, and we all have family members where we have somebody that's a little slow, or we have an Uncle Jojo who's kind of an alcoholic and nobody else can take care of him, you may want to think about a trust to help for special needs, because the trust will actually have these assets that you control as a trustee. It'll go to this person if you're not there or if you're there. And it also gives somebody else the power to maneuver your assets to somebody who has a special need. So think about some of your children. They're all not all created equal, and they're all not financially equal. So you may think about some special needs through a trust. A will just says give it to them, but a trust lets you manage it, so you can do more with the trust. If you own any property, and we just talked about that, if in another state, this is a good way to do it. It avoids conservatorship by having a trust. If you have somebody who say they lose their capacity, you got a little mental illness and maybe dementia, they're going to lose capacity and ability to manage. Well, a trust can allow you to take care of them while you're living. And when you're gone, the trust can continue to take care of them. Because what will happen is when they lose all capacity, the state's going to come in. GSHS is going to come in and take over, put them in a nursing home, charge them $10,000 a month when you could have done the whole thing for $2,000 in your home. But if you have a trust, it can actually put mama in the home, spend the $2,000, and save $8,000 that's going to DSHS. And that's one of the things you want to think about. Conservatorship always happens when there's nobody controlling the money. The state comes in. The trust is also good when you're incapacitated. With a will, it does just what the will says. Once you lose capacity, the will does what the will says. But with a trust, it can maneuver and be more flexible. If you just need help with your living expenses, the trust can actually do that. So there's some benefits in having a trust over a will, but you actually need both. They're just different purposes for them. Next one. The most important thing I can say, other than the transfer on deed, which is very good for us, is a cookie jar. A trust is a cookie jar. Think about it that way. Most of the people get a trust, and it's done, and it costs thousands of dollars or $10,000 or whatever it costs, and they put nothing in it. 70% of the trusts that are made by attorneys like us, no matter how much they spend, have nothing in the trust. My mother included. I told her to get a trust for 10 years. She finally got a trust, and nothing was put in the trust. I said, Mom, the trust is to protect the things. If you put nothing in it, there's nothing to protect. And I don't know why it is. I don't know if it's the cost or what. But you go through all this process of getting the trust, and now that it's done, you're thinking, oh, great, I have this trust. But you got to put something in the trust to protect it. 70% of us do not today in this county, in this church, in this city, do not put anything in the trust. Nothing. You have to put it in to get the protection. So that's important. I just finished a trust with a family on the hilltop, a very known family, and first thing we did was make sure we put something in the trust, because I do not want to be in the 7%. No, not again. Let me tell you the different types of trust. There's two, and this is really important for you to understand. If you want a trust, I'm not saying everybody does, but if you want one, there's a living trust and there's a testamentary trust. The living trust is the one that you can control. You do it when you're living, and you're the trustee, and when you pass, somebody else will actually be the successor trustee, and it can go on and on and on. The other type is a testamentary trust, that when you die, the will pours the money into the trust. So it's a trust after you die, and there's a trust before you die. Both of them are legal, but one you establish when you're living, the other one established when you die. Cost the same. It just depends on what you want to do. One goes through probate. The living trust does not. The testamentary trust does. The testamentary trust has a will that pours over the assets. That's how you get them in there. You'll say, I want the house to go here. I want these assets. I want the boat to go here. I want a motorcycle to go here. And it'll go through the testamentary trust. It'll go into the trust, and then you do whatever you say. That's the two categories, living and testamentary. And then there's another part. There's irrevocable trust and there's revocable trust. So all of you people that are hiding from the IRS, do not raise your hands. You're going to want to trust. If you hide from the taxes and you hide from creditors, revocable trust protects everything from creditors. Nobody will know and nobody can get it. Can't touch it. Irrevocable ones, they might can get to it. It's not that easy, but they can get to it. So irrevocable, you have control where you can revoke it while you're living, and it passes on when you die. Irrevocable, you make it now, and ain't nothing changing. You can't change it, they can't change it, and ain't nothing gonna happen. And after you die, it does what it. The problem with the irrevocable one is you have no control. If you make those changes, if you say you start the trust in 1996, 2025, you want to do something different, you got to go to court and prove to the court that you need to change this and why. That's a lot of money, attorney expense, just to make a change. 70% of the trusts that are made are revocable, the kind that you can control, not irrevocable. So all of you people hiding from the IRS, that's where you might want to go. But most of you might want to go revocable so you can have control. And really, remember I said estate planning is control, for you to control your assets. If you make a mistake, that mistake is done until you go back to court. So you give up your rights if you do a revocable one. Control the property, control of the beneficiaries, control of the chain of the trustees. You cannot, and you can't have a family member be a trustee. Like, for instance, this family I did in Tacoma, the husband and wife are co-trustees right now of their trust. When they pass, it goes to the oldest daughter. And when it goes to the next son, and it goes to the next daughter. So they have people designated who's the trustee. But with a revocable one, an irrevocable one, that's it. It's stuck. And guess what happens to the one that you really set on being the number one trustee? They become a crackhead. And the second one gets involved with gambling. The third one's the only one that don't have a problem. But if you did a irrevocable one, you can't change that. With a revocable one, you can change that. So it's kind of important to be flexible with what you want to do, because if you want to change it, that's what you want to do. A revocable one avoids probate, which is what we're trying to do. Revocable trust, living trust, it actually manages your assets. It actually gives you some tax benefits. Creditors can get to it. So you can't escape Sears and Roebuck. If you owe them, you owe them, whether it's in the trust or not. But here's some warnings, though. When you make a trust and you want your house to be in the trust, sometimes lenders won't let a trust buy the house. You have to buy the house and then transfer it into the trust. Sometimes they just won't do that. Oh, you want to refinance the house and it's in the trust? How are you going to refinance something you don't own? Because when you have a trust, it goes from, Coleman family to Coleman Trust. Well, the Coleman family don't own that anymore. The trust owns it. So it's hard to refinance something. So you got to take the house out of the trust, refinance, put it back in the trust. Can be done, but loses some flexibility. So anybody who's wanting to do a trust, when it comes to putting your house, primary house in the trust, you want to talk to a professional because there's a lot of things, pros and cons, you want to determine, is this good, is this bad? Everybody wants to hide from the IRS, but is it worth it for what you want to do? Sometimes it's not. And, of course, it's more expensive than a will. I'm going to talk about a testamentary trust, and just briefly. The testamentary trust is the one that takes effect after you die. You get a will, says, I want these things to go to my relatives, and I want $50,000 to go to a testamentary trust for my grandkids. And $50,000 goes in there. It takes effect after you die, and then the trustee manages it for those grandkids. So that's another way you can do it. If you have disabled kids or if you have some minor, you can actually use a testamentary trust to actually help them. And it passes assets from you to them without going through probate. It's another way for you to take care of your spouse after you die, too. Because once you get a will and it goes to those people you put in the will, it's in their hands and they can do whatever they want. They can gamble it away, they can throw it away, they can spend it wisely, whatever. But with the trust, you have some control where you actually do more. And you can do more with less. The next one is using trust to transfer your assets. I want to mention 5 different types of trust. Don't want to go into details, but I just want to give you an idea of what they are. A credit shelter trust, which is called like a family trust. This allows you to give an amount of money to your estate and then the rest to your spouse. So it's mainly to take care of your family. And that's called like a family trust. Credit shelter, bypass, or family trust. And there's another one called dynasty trust. This is where you transfer money not to your kids, but to your grandkids or great-grandkids. It's a way for you to skip a couple generations and give to them. That's what some of the Kennedys did. They got some trust that they wanted for the grandkids, and they gave some money to way down there. And that type of trust is available too. And then there's one called a qualified personal residence trust. It allows you to give your home to your children while you're still alive. You control the home, but it's in their name. You still pay taxes, but they actually have title for it. And it's the way you can put it in a trust, give it to them, and you still control it. And then most of us parents, you want to still control. Because, the baby does not manage very well. And you know that. You still love them, but there's ways for you to give it to them without giving control to them. So that's the thing. There's another one called irrevocable life insurance trust, where you have a life insurance policy that creates a trust. And it takes it out of your estate and it goes in there. And there's one that I've heard of the most. It's called Q-tip trust. It's called a qualified terminable interest property trust. It's where you want to give a certain amount of assets to different people in different proportions. So a lot of us I don't know if I'm from Oklahoma, where everything needs to be equal and fair. If you got 3 kids, you give to all 3. That ain't always the best. That ain't always good. And this type of trust, this Q-tip, allows you to give 20% to here, 30% to there, but you got a special needs and you give 40% over here. It allows you to take different interests for, like for instance, you can give 20% of the assets for 10 years for this person, or 10% there, or 40% there. You can do different stuff at different things, and you don't have to be equal, because what's fair and reasonable depends on the circumstances. And that's what you want. And this allows you to do that. Let me do the summary of these probates. Pay on death accounts are one. These usually for the banks. Transfer on death, either transfer a car when you die to somebody else, transfer your deed or your securities or your 401k. And my favorite one is a transfer on death deed, which you have a deed in the name of your loved one, but it doesn't go into effect until you die. You still have the house, you still have the insurance, you still have the control, but it takes it out of probate. And you don't have to do a trust. You don't have to worry about a will. It's just an actual deed that they allow by state law. And then living trust. So remember, you got the revocable one, you can change and control. You got the irrevocable, you can't change and control. And you got the special needs trust. A lot of people want to do that for certain relatives. And then you got the testamentary trust, where it happens after you die. Retirement accounts is another way to avoid probate. Joint ownerships of these different accounts. Life insurance, as the brother already said earlier, life insurance is outside your estate. Do you want to remember that? Community property, half is already out of your control, half is in your control. And then, as Brother Ray already said, small estates under $100,000, that can be done outside of probate. Now, this is what's interesting to me. Contrary to my thought in public, you don't have to do probate in the state of Washington. Do not have to do probate. It's not required. But if you have real estate, you do. If you have land, you do. And if you got some taxes you owe Washington, they're going to make sure you do. So you do if you have real estate. If you don't have real estate, you can avoid probate in a lot of different ways. But because most of us have some real estate, we have to go through probate. If it wasn't for this transfer on deed, there'd be no way for us to avoid probate except a trust. So you got the trust, you got the transfer on deeds, you got life insurance, you got a couple things you can do to avoid that. I want to mention one thing that is new and we haven't thought about is our digital assets. Who controls your password? As a matter of fact, I have a problem in Tacoma right now. I have a client, I'm doing probate, and they've got digital money. They got some Bitcoins, a bunch of Bitcoins. We can't find it. We can't get it. And so what we're trying to do is get the court to give us access to their passwords so we can go get the money. We possibly have $50,000 and can't find it. And nobody will give it to us. I mean, it's amazing. So think about passing on or writing down somewhere all of your passwords so that somebody can actually get them. Put that in your safe deposit box, because sometimes all of our secrets are there, or all the things that's important are there. They're not written out. They're not in a will. They're not in a trust. They're not even with our family. They're written somewhere that nobody can get them. You want to make sure you give everybody access to it. If you get these documents done, and I want you to do that, you want to publish them. You want to give them to your attorney and put it in the safe deposit box, and your executor, and your doctor, and one for you, and for the one aunt that you trust in Oklahoma. I mean, just different places you want to make sure that there's different copies, because if they lose these and you have no evidence of it, what everybody does is they go to attorneys. We have a system in law to find wills. And they put them newspaper ads. I'm doing a will search in Wisconsin. Anybody know about this? Because the one things that attorneys keep are wills and estate planning. We may go away, our practice may go away, but those documents stay. They go from attorney to attorney to attorney to attorney. They never actually disappear. That's the one thing that we keep in the legal field without destroying is wills and trusts, because it's so important for you. But your attorney's gone. Well, that attorney sold that practice to somebody else, and they kept them. So if I went out of practice and it went to Ray, he would have it, and then it would go on and on and on. So you may have a possibility of your will being with your attorney, but that's a risk. I wouldn't risk it. I would have copies. I would give them to the right people. Questions about this? You can do some of this on your own. You can go to Target. You can go Legal Shield. You can go to LegalZoom. Are you going to get what's particular to you? No. You may get a document. You may get something good, but that's not going to do what you want. It's going to do what they want. So I'm not saying spend more money with an attorney. I'm just saying do it right for you. Whatever that is, do it right for you. And a lot of times you'll go to Target and say, oh, here's a power of attorney. And guess what? The power of attorney says you have the power of attorney to do whatever this person said you can do, but if they become incapacitated or can't communicate, the power of attorney ends. Now, when do you need the power of attorney? When they can talk and walk, or when they can't? All the power of attorneys end when you pass or become incapacitated. When you need it the most, it stops. And all of them on the shelves say that. Now, the attorneys know the secret. Durable power of attorneys work when you are in capacity and when you're in capacity. But if you didn't know that, and you didn't put the magic words, yours stop. Soon as they start babbling, it's it. And that's why it's so important to have a legal professional, because you want to get the nuances to help you. And these little things that you don't know will hurt you. Will hurt you. I want to say one more thing before I conclude. Out of all of the things that are important, a will, a power of attorney for finances, a trust, an advance directive, the one that's the most troublesome is the advance directive. That's where all the fights are. It ain't over the money. It's over the hospital. Get all of them done. But that's why I see the most fights. Advance directives create more problems than anything, because usually the family's there, everybody's upset, we're nervous, and here comes the cousin from Nebraska that nobody's seen in 40 years. And they're loud, and the doctor listens to them because they think they're the leader. Get it done, because if you write it down, the doctor will do it. If you don't write it down, the doctor won't do it. So you got to get it done just to make sure.
Here's what I want to do. It's 11:30 now. We're going to go to 11:45. If you have questions, here's a microphone here. We also have cards here for questions. So if you don't get your question answered in class here today, we will give the cards to our presenters, and they then can answer those questions in next week's presentation. Be mindful of them as they plan ahead. Plus, we're going to be establishing a blog so that they can put that information. Kevin's working with us to establish a blog. Hopefully we can get it up this week so that you can send in your questions and we can answer them, and you can go to the blog, hit the website, go to the blog, and then do that. Because of the pressure we're feeling in terms of time, next week moving forward, we're going to go from 10 to 11:45. That also means I need you here on time, because now the 15 minutes we lost on the front end is like gold now. So we're going to open it up for questions. If you have questions, come to the microphone and write it a quarter to. We'll stop that because I know you have them. Now, can I also ask, as Ray said, his presentation is going to be up on the website. Will yours as well? Okay, so this presentation, these slides will be up on the website, so you can go to the website and you can download it and have it. That way you can more easily follow along. Come to the microphone if you have questions.
And a dictionary. One of the things you asked for was a dictionary of all these terms. We have provided you with a dictionary of all these legal terms, what they actually mean in English.
You said an irrevocable trust cannot be changed. Is that correct? So if you're still living and you decide, you know what, we want to change a couple of things because we don't agree with what we changed before, our situation is different, can you change it before a death occurs?
Yes, with a lot of money. You got to go to court, got to get an attorney, and you got to fight it and convince the judge that this needs to be changed. You can change it with a lot of money, but otherwise you can't I just need a change.
What kind of money are you talking about?
Probably $350 an hour is the low end for the estate planning attorneys, and that's who you get to go and challenge that. Probably 2 or 3 hours.
Okay, thank you.
My question is for Brother Keith. You mentioned that 70% of all U.S. trusts has nothing in them because people don't want to go to probate. My question is, why is probate so expensive, and how much does it cost? Is it based on the assets that you have, or how does that work?
Some states is based on assets, and here it's just based on cost. You got your attorney. It's really difficult to do without attorney. You need attorney costs, you have accounting costs, you have research costs, you got cleaning costs, like for the house that grandma was in, it's got to be really rehabilitated so it can go on to a lot of costs. And it takes so long because, as Brother Ray said, you got this waiting period for the creditors. You got the attorney is working on all that time. I have not had an estate go less than a year, ever. And it just takes that long because you got a lot of things to remember. You're trying to find all the creditors, you're trying to get all the assets and pay them and all that. It just takes a lot of time. And attorneys in the estate planning area, they are like $350 an hour. In Seattle, they're $600 an hour. In Bellevue, they're $800 an hour. That don't mean they're that good. That just means what they charge.
Thank you.
It costs $3,000, $10,000. It's different.
You talked about in the trust transferring finances. Does that include stocks and bonds? Would they be able to transfer? You can designate it
Yes.
to grandniece and nephews, how
Yes.
much they can get?
Yes.
Okay, thank you.
You know how you have your 401 and like your retirement, you can make beneficiaries? You can do the same thing with a stock. Or you can take the whole thing and put it in a trust, and now the trust owns it, and it's out of your estate. But it goes to where you want it to.
Thank you.
Yes, this is a probate question. And the question is, okay, after probate is done and you've finished with all your court proceedings, and then 5 years later, the bank calls you and tells you that the decedent had quite a bit of money in the bank, what do you do then?
Happy day.
That's a good question. You could reopen the probate, or with that length of time, the money probably, there's a fancy term, is cheap to the state. Bad word. Means it goes over to the state, but you could still get it through the state recovery department, through the Department of Revenue. In fact, you could go online to Washington State Recovery and put your name in and see if they're holding any money for you. If it matches up, you could file a claim and get it. But with your example, $500,000 after 5 years, you reopen the probate and get it and do the same distribution if it's not already escheated to the state.
Thank you.
You're welcome.
Any other questions? Can you come to the microphone so that they can?
I have a question while she's coming. For Brother Keith. So, for example, Ms. Doe has a son who's on SSI, Supplemental Security Income, which is based on income and resource. And he is on SSI. Would you use a special needs trust for that child to receive his inheritance from Ms. Doe in order not to lose his SSI benefits?
Good question. What I'm suggesting that you might do is talk with your professional, put that in a trust to actually benefit them. So it's not theirs, it's not in their name, but they can get benefit from it. Because what SSI and the government wants to know, if you got some money, they want a part of it. But you having money is in your account. The trust have money, that's their account. So think of a trust as a separate living person. It's different from you, and you can't mix them. So that's where the special needs might come in, where you have it to go benefit. Because what the government wants to do, they'll say, well, how much do you own? Where your income is where your income is. The special needs trust is as needed basis, so it's not necessarily counted against you. And that's why people do that, so they can keep their government benefits coming in.
Now, I just have a question now. Can the beneficiaries get a copy of the living trust once the person is deceased?
Yes. They can get it before. Depends on how you want to do it. The person who needs it the most is the trustee, the manager of the whole thing. They need it because they're the ones going to be managing it. The beneficiaries can get it, but it's not necessary for them to get it. It's not that you're trying to hide it from them, but it's not needed. You can do it if you want. Not a problem.
So how do you go by getting it? You have to go to, because if you wrote to the lawyers, but they wouldn't give you the copy, so you have to go to court?
To get a copy of it, I don't know why the lawyer would actually keep it from you unless the person making the trust said, no, don't give it to the beneficiaries, you would go to court. If they're not going to give it to you, I would say you could go to court to do that. But there's nothing preventing them from giving it to you that I know of legally. It's a choice thing.
Quick question. So I think in Washington State, if I were to transfer my property over to my child and I died within 5 years of that, they go, nope, no good. It reverses back to that person, and then they put the money in probate anyway. But if I put my property into a trust, will that protect it from, if I died within that 5 years, from reverting back over?
I have a depends answer.
Okay.
That 5 years, you're correct. It used to be 3 years. They would look back, and I think DSHS is 5 years, but it's on a case-by-case basis. It's not automatic. It's just that if it looks like you're trying to hide from taxes or hide from the government, they're going to reverse that. But if it looked like you just wanted to do this, estate planning, and you did it, and it didn't look like you were trying to hide anything, it may still be protected.
Okay.
It still may. It's a case-by-case basis. It's not automatic. And what I tell people to do is look at your whole situation and do your estate planning so that when they come looking back, you say, no, in 2019, I decided to get my papers together, and I wanted to do this. I had nothing to do with trying to hide or avoid or anything like that. DSHS will put their fingers in there. The only thing that's good, bad about the government is they will get in your pockets if they can. And one thing about all this estate planning, you got to tell DSHS when you die. It's part of the law. Because if they gave you $1 while you was alive, they want money back. And they'll put a lien on your entire thing at your estate. But if it's in the trust, it's not yours. If it's in a revocable or irrevocable, it's somewhere else. So that's another reason to keep them out. But Sister gave a great question. They will look back at 5 years to see, did you do this to avoid? And the key is, can they prove that you trying to avoid the state paying them back? And not necessarily.
Okay. Let's give our presenters a hand. Here's your homework, or two things. One is your homework. Reiterating some of the things our presenters said. So here's your homework. 3 sheets of paper. Write down what you have. Monies, accounts, stocks, bonds, real estate, personal property, car, jewelry, all those kinds of things. Write down what you have. You got to start writing down what you have. Second sheet of paper. What you think you want to do with it. Who you want it to go to. Can't take it with you. Even if you put it in a casket, it ain't going with you because you ain't going to stay in the casket, just your body. What do you have? What do you think you want to do with it? Third sheet of paper. What are your questions? Some of them will be answered over the next couple of weeks. Some of them will still be outstanding. I'm sure most of them will be. But if you have, and you'll have developed more questions as you go, as you begin to think about all the things you have, what you think you want to do with it, and then what your questions are, and you take those 3 things, and I'm telling you now, though he said you can go to, what do you say, Target or what have you, do it online? No, go to an attorney. Don't do this bootleg. I wouldn't try to give myself medical attention. I wouldn't try to fix my own car. Go to a professional. Make sure it's done right. If you take these things, and go to somebody like these professionals here, you're going to get what you pay for it. They're not going to take all your money with their legal fees. But spend the money to do it right. And then they can help you shape all of that up. Please do that. To avoid the fight of those who are left behind. Don't let the black folk insecurity make you do this thing bootleg or shady or shade tree. Let's do it right. Please, for the love of God and those who leave behind. All right? And then secondly, I know you heard it earlier, but I went into a panic attack when Reverend was talking about Pastor's oldest son. And first of all, my daughter was sitting here. She's my oldest child, thinking, wait a minute, why are you skipping over me? So I knew Carissa was mad. And then I know folks will say, Pastor got another son? No. I got 2 kids. Chris is the oldest, Sam's the young, and that's it. My mama's sitting right here. I got 2 kids. Don't start that. No static. Don't start none, won't be none. Amen. You need to apologize for that. Okay, all minds clear. All minds clear. Let's stand, give our presenters another. Hold on. The bookstore is open for our Lent booklets. So if you have not got Lent for non-Lent people, the bookstore is open to get those. Clarence, you have?
And they wanted you to repeat the 3 homework assignments.
3 homework assignments. Again, the reason why I have you speak into the mic is we're recording this. Okay, the 3 homework assignments. Write down what you have. Because some of you are not thinking in terms of things. Money in the bank, personal possessions like jewelry, your car, your couch, your stereo system, your Heisman Trophy. Stocks and bonds, 401ks, life insurance, what you have and where it is. What you have. Write down what you have. Write down what you think you want to do with it. Because when you sit down with an attorney, they'll give you some ideas on what to do with it. What you think you want to do with it. And then what your questions are. And then perhaps on a 4th sheet of paper, access in terms of passwords. Where is it? Because somebody's got to get to it. So what you have, what you want to do with it, what your questions are, where's it at? And that includes stuff like passwords. Is that? That's the stuff an attorney is going to need when you go to them and try to put all of this into a framework. All right? Everybody got the homework? We'll see you next week. Commit this covenant with God. You will be here each week. This ain't sexy like some of the stuff that's exciting. This is sitting down and come, let us reason together. Amen. So we leave this world decently and in order. Amen. Stand to your feet. We'll see you next week. God bless you. Have a nice day.